Good
Hi. Good afternoon, everyone. I'm Gail Vangeliti and Liliana McCoy with the Public Defender's Office, or not Public Defender, I'm sorry, Public Guardian's Office. We will both be doing the presentation today. This presentation will be recorded, so please, if you're talking, don't use your loved one's name for their privacy. It would just be respectful. And hold all questions to the very end. What I'd like to do is thank Araceli Hernandez for being the webmaster and helping us get this whole program together. She does an amazing job. She keeps us on track and moves us along as we need to for the program. Maddie Cobbs with Urban LA, NAMI Urban LA, and Harold Turner are also very instrumental in promoting this program and helping us to get it through. We also have the Department of Mental Health in Los Angeles. All the information is basically pertaining to Los Angeles. And what we do is we're not attorneys, doctors, social workers, or any other such thing, but we share with you what will give you the greatest probability for success for recovery for your loved ones. And right now, most of you either are in the process of getting an LPS conservatorship, or you have already gotten the LPS conservatorship. And that's what this program today is set up for, because a lot of people get the conservatorships and it's kind of like, now what? What do I do? What can I do? What are my powers? That sort of thing. So between Liliana and I hope we answer a lot of your questions, give you guidance, tell you what the laws are, because the more knowledgeable you are, the better off you are. Also, if you have not signed up and taken the free family to family class, I strongly suggest that you do it. It empowers you to be able to have better understanding in guiding your loved one for recovery. Okay, next slide. Today's presenters are Liliana with the Office of Public Guardian. And anytime you have any questions or concern, you can always give her a call, and then me. You can always call me. I have no problem with that. Now, in the month of December, I'll be heading back to Florida for a bit. So please keep in mind there is a 3-hour time zone. When you get up and you're having your cup of coffee, you're welcome to ring me. But at nighttime, unless it's an emergency, I'll wait and call you back the next day. Next slide. These are the people we want to thank. And I'm telling you, Araceli, I don't know what we'd do without her. Next slide. This is a disclaimer just to let you know that we're just trying to give you the feedback that we get when people have success. We share it with you. So we want you to get your loved one on the road to recovery. Once you've gotten that LPS conservatorship, look at the photo album, remember what your loved one was like, and that is your target goal. Recovery is very possible. So maybe not exactly where they were, but pretty darn close. We just make suggestions. You know your loved one better than anybody. You are in the moment. And if we've made a suggestion, and it sounds like we're telling you what to do half the time, but it is just suggestions, you make that decision. And if it's not the best decision at that particular time, don't worry about it. Don't beat yourself up. Go back and just do it again as needed. We'll give you the laws to help you make decisions. And basically, this information is pertaining to Los Angeles. The state laws are the same, but how it's implemented in the different counties makes a difference. And Los Angeles, we're blessed because we have a board of supervisors, the Department of Mental Health, who are all engaged in making a difference and helping those who need it. Next slide. These are tips. Once you become a conservator, if you are the conservator, and we can have 2 people as conservators now, always refer to yourself as the conservator. Don't say, well, I'm his mother or his father, because people don't pay attention to that. But if you say, I'm his conservator, it elevates you to a new level and people pay attention. Keep two journals. This is extremely important. One journal is pertaining to your loved one. It tells about the medications he's on, when he started them, the dosage he or she is on, the results that you're seeing from him, and if there's any side effects. That is really important because it does help the doctor to do a better job on medicating. Also, keep the second journal with anybody you talk to. The date, the time. When people call me, I tell them, I want you to keep that journal. Even me, put that in there. And, I give them a whole lot of information. I say, just put LPS information because I know what I've given you. But anybody you speak to, you write down what they're saying. And if they're telling you something that doesn't make sense, just say, okay, how do you spell your last name? That's Smith. How do you spell that again? It's the Smith. And what you are telling me is, when you repeat it back to them, that's what you're writing down, unless they correct it. Get involved. Join NAMI. It's one of the best programs you could ever do. Help out and get involved. You'll meet a lot of people that are very helpful, supportive, and believe me, you need it during all of this. Next slide. Okay, the LPS conservatorship, if you were in the class yesterday, I know you've heard all this. It's the term used in California for involuntary mental health treatment. Each state has a different term for involuntary mental health treatment. Most of them use guidance, guardianship, or a conservatorship. But in California, this was named after the Latterman, Petrus, and Short legislators, and it came into effect in 1974. You can read the laws. They're in the California Welfare Institutions Code. These laws are over 50 years old, and they don't reflect the current scientific research. Now, just a heads up, as of December 1st, things are going to start changing because a lot of laws have been changed. The definition for gravely disabled, and we're going to talk a little bit about that. The old definition, we'll go over that, but we're also going to go over the new one. And Liliana will keep us up to date on things. And Liliana, I think that was your slide. Next slide. Liliana.
Okay, forms for conservators. After you become the conservator, there is a booklet that is given to you. It is called Helping Your Loved One, and it's a guide to help you, day-to-day duties and responsibilities about being a conservator. If they do not give one to you, you can find it on the internet. The website is on the PowerPoint. So if you want, you can write it down so that you can access it at a later time. Next slide. One of the essence of a conservatorship is involuntary medication. This is one of the most beneficial parts of the conservatorship is that, facilities where your loved ones are located can involuntarily medicate your loved one if necessary. A lot of times just having the conservatorship itself is enough power to make the person do it without being forced to take it. So involuntary medication orders, very cool in a conservatorship. Next slide. Okay, so here the address to where the mental health court is located at. It is now in Norwalk. The presiding judge is Scott Heron. He has been there a little less than a year. He started in March, and he's tough. He's tough, but he's tough with everyone. And that includes private conservators as well.
He's also very fair, and I think we've been real pleased with him. Sometimes we get judges which really don't understand mental illness, but I think he does, and he hears what everybody has to say. He doesn't say, well, I don't want to hear from you, which that's happened in the past. So far, we're real pleased.
Yeah, he's tough but fair, as Gail said. Next slide. Okay. So the types of LPS conservatorship, we have conservatorship of the person and conservatorship of the state. So the public guardian is the court-appointed conservator. We get both types of conservatorship because we will manage the person's benefits. That includes SSI and SSA. Usually private conservators are only appointed conservatorship of the person. Here, the doctor initiates the conservatorship. So if you are in this class, you most likely have a conservatorship, so you know how difficult it is to get a doctor to file the application with our office, but that's where the conservatorship initiates with the psychiatrist at the acute setting. So most of this information in this class pertains to the conservatorship of the person. Next slide.
Wait, let me just add something on the conservatorship of the estate. If they have school loans, loans that they have to pay back or should, court cases, you can ask the public guardian to help you get the conservatorship of the estate so you can handle all these things. Your school loans, pretty much you can get those waived. They have to be under minimum income for like 3 years, and then those are completely taken off the record. Your credit card loans and all that other sort of thing, if you have money to pay back, you can pay it back, generally working with the creditor, like 10 cents on the dollar, 25 cents on the dollar, something like that. And that's also be helpful. Plus dealing with criminal cases that they may have. This helps you with that. So sometimes you need the conservatorship of the estate to find out what loans they might have out. You can do credit card or Credit Karma and just run that on the internet and see what they owe. And that helps to establish the conservatorship of the estate.
Right. There are some clients that do have property, cars that need to be managed. In those types of instances, the court can grant the conservatorship of the estate as well. Otherwise, as a conservatorship of the person and you need benefits established, you can apply to be the representative payee.
Mm-hmm. You don't need to have the conservatorship to be a representative payee either. So you can do that before you get the conservatorship.
Correct.
Okay.
Next slide. Okay. Succession of conservatorship. So if at any time you as a private conservator feel that it is too difficult, you know, a lot of times we have circumstances that, you know, require us to put in a lot of time and you might not be able to continue with the duties of the conservator, you can write a letter to the court or contact your court-appointed attorney or your loved one's public defender and let them know that you need to resign as a conservator, and that matter will be put on the court's calendar. This can happen at any time during the conservatorship. At the same time, if you know the public guardian is the conservator and you decide that you want to take over, we can certainly request that the court put the matter on calendar so that we can transfer the conservatorship over to you. All it requires is a letter to the court, include your loved one's name and the court case number, and it'll change. It's very easy.
Mm-hmm. And it doesn't take very long, maybe a week to 10 days. The other thing is you can have 2 conservators in Los Angeles now, and you don't have to be living in the state to be a conservator. but you do have to be in a position where you can help out when needed. We were living in Louisiana in conservators, and that was not a problem. If I had to fly in for something, I did. But if you have to be hands-on because you do have a certain role that you play.
Correct. With COVID, a lot of changes happened. A lot of meetings happen now through WebEx. So you don't need to necessarily be present. You just have to be available for when these meetings occur so that you can do the treatment team about your loved one's treatment, medication, maybe change of level of care. They're recommended to discharge from wherever they're at. You just need to be available. Likewise, if facilities feel that you're not doing your duties as a conservator, they can also submit a request to the court to have you removed. So I do want to let you guys know that that could also be a possibility. Next slide.
Okay, who should be the conservator? There's pros and cons for each. The public guardian, if the public guardian's a conservator, they are able to place a person in a state approved facility. And hospitals sometimes, once they're conserved, they're in the hospital, they have to remain in the hospital until a bed becomes available at a facility. It makes it kind of difficult because the hospitals put pressure on families to take them home. I've had them tell them, well, take them home. We've applied for an IMD, that's the Institute for Mental Disease, which is a lockdown treatment facility, and we'll let you know when it's available. Well, if you take them home, they're no longer eligible for that IMD. So that's the hospital telling you something that's not legit. And that happens quite often. So they have to go from a lockdown facility to another lockdown facility. Hospitals and jails are locked down. That's pretty much the only way you're going to get into an IMD. Those are locked down, so you can go to the lockdown. If you take them home, they're no longer eligible for that lockdown. But the public guardian is very good about getting them in a facility. So if the hospital's giving you trouble, you might say, well, keep it with the public guardian temporarily. Then as they get better, you can take them. It's a lot less stress for the families. Being a conservator is stressful. One, because your loved one puts a lot of pressure on you. I want this, I want that, get me out of here, that kind of thing. With the public guardian, they get a little bit of that, but not, they don't have the emotional attachment that a parent does or a child does with their parents, whoever is the conservator. The negative is you're less involved in the recovery process because you don't have the control of anything, and you have no control for medications. And unfortunately, a lot of doctors will put patients on, well, maybe not a lot, but doctors, some will, put them on medications that are not good for them. And you're seeking recovery. You want them to have clarity of thinking with the least side effects. And if they've got them on medications that are good for a person who has a mental health problem, it isn't going to do your seriously mentally ill person any good. Look at it this way. If you have a migraine and I have a headache and I say, take my Tylenol for your migraine, it won't phase it. It's the same with medications, and we'll go over that shortly. But there are a lot of medications that don't even phase a person with serious mental illness. So, and just keep in mind, I am not a doctor. I've just done this for a long time. I'm relaying to you the feedback that I get from other people. Okay. If the public guardian is a conservator, work to establish a working relationship with the public guardian. Keep in mind, if you're the conservator, you have one person you're dealing with. The public guardian's dealing with what, 50 to 70, Liliana, people that you have to deal with?
80 clients.
80. Oh my
Yeah.
God.
Yeah, we have a
It's gone up. It's really gone up.
Yeah.
It used to be 50 to 70, but now 80. That is a lot of people to have to keep track of, know how they're doing. It's difficult. It really is. So be respectful of the public guardian's time. Don't call and want to tell them your life story. They don't have the time for that. The best thing, and correct me if I'm wrong, Liliana, is to email them your questions. That way they can answer it. And when they're in the field, they're working with their clients. They are not going to be answering the phone to a relative that wants to know what's going on. So your emails are probably the best way to go to find out what you need or let them know what's going on. Okay, you want to add anything, Liliana?
Yeah, if the emailing is always the best because we can always set up a time and a date to talk with you more in depth that we would be able to do, over email. So emailing your availability, your questions, maybe it's something that they need to follow up with the facility about. So email works a lot better. Because remember, we also have our clients have our direct phone numbers, so they also call us often as well. So we can't be on the phone all day. We try to answer as many questions as we can, but setting up an appointment with the assigned public guardian through email works much better for everyone.
And be patient with the public guardians. They are doing their best. And we're very fortunate. We have very considerate, kind public guardians. Okay, next slide. Should you be the conservator, the pro is you have direct contact with the doctors. And when a person goes to a facility, be sure to tell that facility there will be no change, and we'll go back over this again, no change in medication, treatment, or placement without your direct written permission, because they'll try to push you around. And there's a form that they have you sign, which is giving them permission to treat your loved one. Translated to that facility many times, not all of them, but is, well, you're out of the picture now. They've taken over your conservatorship. No, you are the conservator. Your power is to approve or disapprove treatment, placement, and medication. So you have direct contact with the doctor, but most of the time you go through the social worker or the charge nurse. And only when you have to talk to the doctor can you set up an appointment. If they refuse to let you talk with the doctor, you can contact me or Liliana, and that's taken care of. I will direct you to probably Dr. Ruiz to give her a call, and she will call the facility, and that will be changed. But facilities, they don't expect you to be knowledgeable, so they will try to push you around, but they're learning. We have some knowledge here, not much, but some. You can reject inappropriate treatment facilities, medication, and treatment places, as that's the big thing about being a conservator. And I'll give you an example. We had one young man, very bright, but his paranoia was people would get close to him. You're 6 feet away and you're in my space. Why are you in my space, kind of thing. And a substance abuse program. Went to one facility. They were packed in like sardines. There were 4 to a room. Your only privacy was like a shower curtain around your bed. That would not have cut it. And the place was small. And I mean, there were a lot of people there. That just wasn't going to work. The second place, it was people who were more low functioning. Now, this person had catatonic schizophrenia, so it wasn't really talking. And so when they did the evaluation, that's where they thought it would be most appropriate. It would have freaked them out, because the brain works. It's that frontal lobe that's not processing. And the third place, they're selling drugs across the street. So it's the hospital contacts the institute, what is it, Liliana, the intensive care division. They contact them to come and do an evaluation and suggest 3 INDs. As a conservator, you can go to that facility and you can say yes or no. None of them are great, but then their clients aren't so great either. So you know your loved one the best, and you can say, yes, this would be a good facility for them, or it would. and work to get them into that treatment facility. Although, keep in mind, beds are limited. We're opening up more IMD beds, but they are limited. So sometimes you can't be but so picky on that. But that's one of the things that you can do. Your power is to approve or disapprove, so you can reject an inappropriate treatment facility. The negative is your conservatee manipulates you. If you can't say no to them, let the public guardian be the conservator, because they will drive you crazy. And I suggest to families, when you go to visit them and all they're saying is, get me out of here, I want to get out of here, stop them. Just say, okay, you have to become tough. You really do. You say, look, I'm coming to visit you. If this is the only conversation we're going to have, then I'm going to turn and leave. And when you go to visit them, if they start up, don't say, I'm counting to 3, I'm counting to 4. Don't say that again, because they're going to do it again. You just say, okay, we had this conversation. I don't want to listen to this again. So I will see you later and we'll try another time. You do that, I'll guarantee you by the 3rd time, they will not be doing that, and they will be working with you much, much nicer. The other negative is the hospital will push you around and want to discharge your loved one to a facility that's not appropriate for the level of treatment that's needed. So that's, you have a lot of stress in that regard, but you can handle it because now you're in control. Liliana, you want to say anything on this?
No, I think you covered everything very well.
Okay, next slide.
Liability for being a conservator. By law, you're not liable, either civilly or criminally, for anything that your loved one may or may not do. They're still their individual person. You're just overseeing their mental health treatment. So you won't be liable. You are also not financially responsible for any of the conservatee's debts. I think that scares a lot of people, that they might be responsible for the cost of the care that, if they're in a treatment, but you're not financially responsible for that either. I don't know, Gail, you wanted to add anything?
Yeah, if other states will they might use the term a guardianship. And sometimes people from other states come to California and they say they want a guardianship. You do not want a guardianship, because then you are responsible for anything the conservatee does or doesn't do. For instance, when you've gotten a conservatorship, generally they take away the person's right to drive a car. If you give them the keys to drive the car, then you are liable because they're not supposed to. But if they took the keys to the car and drove it, you are not liable. Of course, your insurance company might think something different, but you're really not liable for anything they do or don't do or any of their debts. So keep in mind, you don't want a guardianship in California, because that means you could be sued. Okay, next slide. The rights and responsibilities of the LPS conservator. This is what I said earlier. You have the power to approve or disapprove all medications, treatment, and placement. And on medications, I'm going to cover this now. Be sure you have that journal, that you're putting down what they're taking, what you're observing. Now, anything they say, you can write that down. This is my suggestion. Do not correct what they are saying. If they're saying, talk about some wild thing or they're going to do something bad, write it down, talk to the doctor about it, but don't correct what they're telling you. If you correct them, chances are they will clam up and stop talking to you about their delusions or their voices or anything at all like that. You want to know what they're thinking at all times, even in the recovery process, because the recovery, you'll go up 3 steps and back 2, up 3, back 2, takes a while, but you want to know what they're thinking. What you can say to them is, I'm sorry you feel that way, I just don't see it the same as you. Or, I'm sorry you feel that way, that has to make you feel very uncomfortable. Don't correct what they say so that you know what they're doing. On those medications, the medications that I have gotten feedback from that don't tend to work, Cyprexa, it will work a little bit, but it really doesn't give them clarity of thinking. You want clarity of thinking, and Cyprexa is Cyprexis, I think it is. It will blow them up like a balloon. Now, keep in mind what medication works for one doesn't necessarily work for another. But everybody I've talked to whose kids have been on Cyprexa, they have put the weight on. I've not had anybody say that it did not. I had one kid that was 400 pounds. That was really bad. But there might be somebody where it works perfectly good for. But generally speaking, the probability it's not going to. Depakote, Ativan, Seroquel. Seroquel helps a person to sleep at night, but it really doesn't do a very good job giving them their recovery. The ones that I tend to hear on the feedback, this is just my opinion, Invega, Invega, I would say 85% plus, maybe pushing 90%. People get a lot of clarity of thinking, but it does come with some side effects for a lot of people, and a lot of people it doesn't. Invega and Risperidol are identical chemical compositions. It's how they're delivered in the system. Risperidol goes to the cell, and all those organelles in the cell that you learned about biology years ago, if you remember, they all send out different messages. So generally, the person tends to be more tired, less motivated. You'll get a few more side effects, but not very energetic. Invega, they tend to be more motivated, less tired. They might take a nap in the afternoon, that's fine. And more clarity of thinking, because the medication goes to the nucleus of the cell. So that is one that I tend to like. Plus it comes with the shot. Now, just a note on the shots. Generally, all these Sustaina shots will tell you every 4 weeks. Your loved one's metabolism metabolizes differently. So if they metabolize rapidly, they may need a shot every 3.5 weeks, pushing 4 weeks. So if you're noticing at 3.5 weeks, they're really getting out of whack, and I'm not going to take that medicine, I'm not going to do this and that. You may have to make it every 3.5 weeks. But likewise, if they're a slow metabolizer, and 4 weeks comes and they're doing great, you could try 4 weeks 1 day, 4 weeks 2 days, till you find out where they really need it. But it's generally suggested by the pharmaceutical companies that every 4 weeks. And you can call any pharmaceutical company that makes those products that your loved one is on and talk to them about anything. They will tell you everything. So Invega's one of my favorite medications, because we get results within 3 or 4 days, which is kind of nice. Latuda is another one that's very good. I don't think it has a Sustaina. A couple new ones that have come out now, Caplyta, Caplyta. I have not had anybody in California on that I'm aware of, but in Florida, quite a few psychiatrists they're doing the happy dance with that medication. So that's usually a pretty good one. Vraylar, Vraylar, is another one that I've had 9 people on it. 7 have said it's the miracle drug. to have said, "Oof, it was disaster." So like I say, what works for one doesn't work for another. So you start out slowly and titrate up. And when the person's on medications, you want to titrate them slowly off of these medications. And if you can find one, you work with the doctor. You can't tell the doctor, give them this, give them that, because the doctor is going to say, and where'd you get your degree from? Yeah. But work with the doctor. Just say, I've been reading about these medications, and this one looks like it may work for my loved one. How about if we try a small amount? I'm keeping records and I'll give you the feedback, what I think about it or what what the results are with them. The doctors tend to like that a lot because they have a lot of patients. And if you can help them out, they appreciate it if you're working with them. But the moment you start telling that doctor what to do, they're gods and they're going to shut you out. And they can even take you to court and have you removed as a conservator. So be cautious, work with the doctor, work with everybody. Don't fight people because they're there to help you with your loved one. And you want to get on board for the same thing. Okay, Liliana, you want to ask it? Any questions?
I do want to, for the medications and the treatment, as a conservator, it is only for mental health treatment, not for medical treatment. That is a completely separate request of the court. And I think we'll get into that later, Gail.
Okay, yes, I think it does come later. Okay, next slide. Let's see, you have the right to speak directly with the treating doctor. So when a facility tells you we don't speak to our doctors, that's not true. Just give me a call. I'll give you Dr. Roos's phone number. We're drowning you with a lot of information now, so I don't want to overload you. And chances are you won't come across that, but when you talk to the doctor, write down your points of what you want to say. And the same with the public guardian. Be respectful of their time. Hit your points, and then that's it. Don't go into, my loved one was doing this the other day. People don't have time for that. They really don't. And because they do have so many patients. As a conservator, you can apply for SSI, SSDI, Medi-Cal, Medicare, and VA benefits, whatever you need. And you can also have private insurance along with your Medi-Cal and Medicare at the same time. Now, when it comes to getting the resources, that SSI, SSDI, that's income. The Medi-Cal, Medicare, that is insurance, you might say, medical insurance. You don't have to wait for the person to be under a conservatorship to get that. Call Social Security. Remember the history, symptoms, and gravely disabled? Give that to Social Security and tell them, I would like for you to help me fill out the forms. They know which one your loved one would qualify for because they have all the records, their work records, and they can tell you whether it's SSI or SSDI. So you want to get that, but you want them to help you fill out the forms. They're going to be in the hospital. When they go to the hospital, give that information to the social worker to get them to sign it. The social workers at the hospital are pretty good about getting people to sign it. So they do their best anyway. But you have 3 months to get those signed. And for Medi-Cal, you can also request emergency Medi-Cal. So that will help with your copay if you have private insurance. All right, Liliana, you want to add anything?
No, I think you covered it, but for SSI, if this is the first time that you are going to apply for your loved ones, it is going to take a little bit because the Social Security office has to determine based on medical records that the person is disabled because of a mental illness in order to receive that benefit. For SSDI, that's money earned, through work. They're entitled to that. So a lot of times for our clients, when we are the conservator, we apply for SSI individually and long-term Medi-Cal so that there's no lapse in insurance.
Mhm.
For VA, that's a little harder to get. A lot of times the VA, they'll appoint their own fiduciary to manage those benefits.
Okay, next. Is that it?
That's it. Okay, California Welfare and Institutions Code 5358.5. So as a conservator, you have the right to hospitalize your loved one when you deem necessary. So if they're having an episode and they're decompensating, you have the ability with your letters of conservatorship to hospitalize them as a 5150. You don't have to wait for the person to decompensate to the point where they're a danger to self or danger to others. If they're having some sort of breakdown, you can call 911, have them, or the PET team, MET team, SMART team, any team that can come and evaluate your person to have them hospitalized. If you're having issues, you can contact Miriam Brown. She's the deputy for the emergency outreach and triage with DMH. Her phone number is listed on the slides. Make sure you write it down so you have it in case you're having trouble having your loved one evaluated.
Mhm. Also, in that pamphlet that you have, the Guide for Conservators, if you don't have it, email me and I will send it to you, Guide for Conservators. In the resource section and even in the LPS information booklet, you have all these resource numbers on there. Now, let me just say something. The problem we're having now is the police don't want to put hands on anybody. And they would rather walk away, which has become really a problem. And we sometimes when somebody's mentally ill, you don't want them to run into a problem that they end up in jail. So if you're having trouble, if you can get like the SMART team, that team like Liliana mentioned, they are an evaluator and a police combination sort of, and they can usually help. But if you really run into a tough problem, then I would suggest that you call Dee Dee Hammond. I'm going to give you the number. You can use my name and tell her that I asked you to call. I'm not sure which one works. One of her numbers works. 213-471-3049. And the other number that I have for her is 626-807-7806. She is an evaluator and she works with the police, and she will do everything she can to get your loved one to the hospital. Now, if I can make a suggestion, if your loved one's gone off their medication for a week, don't sit and wait for 2 weeks, 3 weeks, months to go down, because they're getting sicker and sicker. If they go off their medication, you as conservator, according to the law, when you deem it's necessary, you can have them placed back in the hospital. The hospital is the only place that can really force medication. So you want them back in the hospital. They've gone off their meds for a week. Get them in the hospital. And by law, you can request police transport. That's what all this is about. That's the nicest thing about the LPS conservatorship, this particular code. It gives you the right to do this. The court has ruled your loved one is gravely disabled, so you really don't need an evaluator, because nobody can evaluate and say they're not gravely disabled, because they would be in contempt of court. So your loved one has been ruled gravely disabled. That's how they got that LPS conservatorship. So when you deem they have to go to the hospital, you have that right to request the police to transport them to the hospital. And back to the, every time we have a good law that's going to work and it was working great, then the police go, we're not going to put hands on them. And I understand where they're coming from, because everybody's got their cell phones. tell your loved ones if they're around, put your cell phones away, because the police won't even, they're just very cautious what they do when they see the cell phones. They're still cautious. I mean, you don't want them slamming them to the ground or anything like that, but they will lose their pension, their jobs, everything if your loved one hauls off and does something that could be a problem, and then they have to restrain them. And so you want to protect both the police and your loved one. If you wait for months, your loved one gets sicker and sicker, and you don't want that to happen. Your job as conservator is to keep their recovery in a forward motion of wellness, not to let them backslide. And if you call me and it's been 6 months and you haven't done anything, don't expect me to be a happy talker to you, because I won't be. I'll be very firm, I won't be rude, but I will be very disappointed if you're the conservator and you've allowed that to happen, because you've been given an important role in life. The public defender, public guardian, I mean, they don't do that. And they do, what is the term that you use, Liliana? The AD something?
Oh, the authorization to detain and treat. So
Yes.
when your loved one goes into a facility, make sure that they have a copy of the letters of conservatorship, which tells them exactly what your powers are, the right to medicate, the right to hospitalize, and along with what we call an authorization to detain and treat. So that allows the facility to provide them with the medication that they need to continue with their mental health treatment.
Next slide.
Okay. So the Welfare and Institutions Code 5358.5, like it said, is a decree that says that your loved one is gravely disabled, meaning they are unable to meet their basic needs of food, clothing, and shelter because of their mental illness. So with this law, the conservator can request that the police transport to a hospital for treatment, even if they're at a IMD. If you are the conservator and your husband and your loved one is at an IMD and you feel that they're decompensating, you can use this code to have the police transport them to the hospital for treatment. Again, the hospital is the only place where they can force medication for stabilization. And as a conservator, you are authorized, because of your letters of conservatorship, to have them detained and treated.
Okay, next slide. This is the authorization. Liliana, why don't you take that one?
Sure. So this is a letter that you would provide whatever facility your loved one is in, authorizing them to detain and treat your loved one. So you're going to include their name and the powers. So here we have power 6, 7, 8A. It's very clear in the letters of conservatorship, so you can just include power 6 like it is here, but the letters of conservatorship explains exactly what those powers are. So it's always an idea to include both documents and give them to the facility. I believe this form is also on the Superior Court website in their mental health forms. So if you want to just print it out from there and have it ready, just leave the 2 blank. So in case you need to hospitalize your loved one, you can just easily write it in. You can have blank copies of it, keep them readily available in case you need them. Usually the letters for privates are sufficient, but sometimes facilities like to have this authorization to detain and treat because it'll have your signature at the bottom as a conservator. Next slide.
Okay, Cal-Able. Before, like if you are on SSI, and this pertains to SSI, not SSDI, the person cannot have more than 2,000 in the bank at any time. Don't let it go to 2001, your representative payee, because chances are you'll be audited. It's not a big deal, but it's stressful. You have enough stress in your life. You don't need any more. So keep all their accounts under 2,000. Now, as parents, we know we give extra money to our kids. So let's say you're putting them in a treatment facility or a facility a little bit nicer, and you're going to subsidize $200 or $1,000 a month or whatever. Go online, open up a CalAble account. You can put money in the CalAble account, and you can use that money to subsidize their rent, food, whatever needs they have. It has a whole list of things, almost anything they're going to need, school, you name it, that you can use that money for, and it does not go against their SSI money. So they don't take that out, because otherwise, like for every $2 you substitute and you help them with, SSI will cut down $1. So if you're subsidizing their rent by $200, well, SSI's cut it back $100. Now you owe $300, not $200. So use CalAble if they're under SSI. And sometimes when they're transferred to a treatment facility and they're under SSDI, they will have to give them SSI to supplement the difference. Once you see SSI, be cautious on giving them money and paying for anything unless it's coming through the CalAble account. And don't put a lot of money into CalAble, just some, and use it as you need it. And then you can keep adding to it. But if you look up CalAble, the California passed a law so that people who are mentally ill or anybody who really needs SSI, that they can get extra things without it going against they're not going to be losing their government funding. All right, next slide. These are some of the things that they cover with for SSI: housing, education, transportation, employment, health, prevention, assistant technology, personal support, and miscellaneous expenses, which covers a wealth of things. Next slide. Liliana?
LPS Conservatorship of the estate. So as the conservator of the estate, you are able to negotiate debts. You are able to handle criminal court cases, acquire a waiver for school loans, cancel credit cards. So you're, as the conservator of the estate, you're responsible to manage the finances. So anything that the client is responsible for, you as a conservator are able to handle on their behalf. You can ask the court to appoint you an attorney. Always get a court-appointed attorney. It's free to you, and they can help you navigate conservatorship legal issues, whether it be of the person or of the estate. Any questions you have, your court-appointed attorney is able to assist you.
That court-appointed attorney, be sure to always ask for one, because if you have any questions during the year or renewing the conservatorship, that court-appointed attorney is an attorney that you can go to directly and say, I need help.
This is the attorney is for you to represent you as a conservator, not the client, because the conservatee is given their own attorney during the conservatorship process. So this attorney is to assist you, and even with placement, if you have placement issues, the attorney can assist you.
Liliana, correct me if I'm wrong, but if you did not get an attorney when you got the conservatorship, you can still go back and request that the court assign you an attorney. Is that correct?
I believe so, but I believe the matter has to be put back on calendar. Let me double check on that for you, and I will send you an email about that.
Okay, thank you.
Next slide. Conservator must have court approval. This is true. So because this conservatorship is meant for mental health treatment, Any treatment outside of that medical treatment, we must get court authorization. So you need to do what is known as a 7-point letter outlining exactly what the treatment is required, any medical treatment, even a flu shot. We need court authorization because anything that pricks, poke, requires us to notify the court, because the clients, although they're under a conservatorship, they still have the ability to make decisions if they have the capacity for these medical procedures. So the treating medical doctor will let you know exactly what the procedure is and whether or not they have the capacity to understand the risks and benefits of the procedure. Along with that letter from the medical doctor, the treating psychiatrist must also fill one very similar to let us know whether or not the client has the medical or the capacity to understand. So if both doctors say no capacity, then it must be put before the court. If one of the doctors says yes, the other one says no, we need to put that before the court. If both doctors say yes, the person does have the capacity to understand, then usually we just have our attorney review it and they give us the go-ahead, and then the procedure is done because the client understands. So the same is for private conservators. Any medical procedure we need to notify the court. And if you have a conservatorship, that meant that it went through the public guardian first. We did the investigations. We would notify the court of all known medical issues and medications that are taken for those medical problems. And at that time, we get granted Power 12. It's for the non-invasive treatment of medical problems. So if our client has diabetes and they're taking metformin, then we have the ability to approve that medication because we notified the court and the court granted us that authority at that time. Anything that was not listed at the initial conservatorship appointment, then we need to get court approval for. Do you have any input, Gail?
Yes, emergency. You want to cover emergency situations?
Sure. If in the event the medical procedure is emergent, then the hospital can do it based on their protocols. Usually it's 2 doctors signing off on the medical record that the procedure is being done as an emergency. And then that covers you as a conservator of liability because it was done as an emergency.
But you have to go back and inform the court this did take place.
Right. Yeah. We'll notify the court, but
you do, but the private conservator would have to inform the court.
Yeah, because I mean, the court knows everything, and eventually, even if you don't know, if you're not notifying them at that time, the court will know because there might be something else that needs to be done and there's time to do it. And at that time, you have to notify the court that you need this new treatment and why, and it's because the person had this emergency procedure. So now we need to do additional medical treatment and you have time to notify the court. So you would still ask permission.
Okay. I'd like to add one more thing to this. If your loved one's in a treatment facility and they develop a problem, sometimes like on the weekends, the treatment facilities have skeleton crews that are not very well educated. And they may say, oh no, you can't take them out. You can't, which, you know, you might have to take them to the doctor if there's a problem. And if they do not let you do that, you can still have the right to take them out because you are their conservator. And the facility, like an IMD, might say, well, we're not going to hold the bed or anything. They have to while you take them to get this treatment. If it's, you know, a serious like Mercer's, Mercer's can travel through the body really fast and cause problems. So can other illness. If they're running a fever and they're trying to keep them in that facility, you can, when you deem it's necessary, you take them out, you get them to the hospital, and then you can deal with all this other stuff of notifying the court and all that other stuff, but get them treated because you don't want them to develop a serious medical problem. You want to nip it in the bud.
Correct.
Okay. Okay, next slide. Oh, sorry. I was there already.
Okay. No experimental treatment is permitted. So I'm sure you guys have all heard of Paxlovid, the emergency COVID treatment that hasn't been approved by the FDA. A lot of our clients were asked that got COVID. The doctors ask us if we are able to approve that. And unfortunately, we were not because it is considered experimental and not FDA approved. So for medical treatment, this also includes any dental procedures, not just what we consider medical. Dental work is also, we also need to notify the court and get approval for. Next slide.
Well, Liliana, I have a question. How is it that these facilities were able to demand COVID shots?
We have COVID
COVID shots.
well, now they're approved, so we are able to get court authority to approve COVID.
They were FDA approved?
I think because it was an emergency, they were able, but not the medication for when the person got COVID.
Not even a capsule or pill or something because those were not approved?
Correct. And
Oh,
it was, I don't even know how to explain it, but it just, because of the
a
pandemic,
mess.
it was a, yeah, I should say.
That's a good explanation.
Sorry, I don't have a better one. We just know that it was everybody. It's because a lot of our clients were living in these, you know, lockdown with so many people that it's necessary to make sure that they were safe to get that medication. But not the medication if they got COVID. I know it doesn't make sense. It sounds counterintuitive, but that medication we would not be able to approve.
Oh, okay. Right. Next slide.
Conservator had direct contact with treating doctor. So as a conservator, you have the right, based on the WIC code 5328.1, you have the right to ask for the prognosis, the list of medications, side effects, pretty much all their medical records pertaining to the treatment of their mental illness. You as a conservator have that right. That's given to you based on this code. And if the facility has issues with you obtaining those, give them the letters of conservatorship along with a copy of that code so that they can give them to you. You also have the ability to have direct contact with the treating doctor. And if they're refusing you any contact with the doctor, first try the administrator of the facility where the client is at. Maybe the doctor doesn't know. Maybe he doesn't know that you're the conservator. Try reaching out to the administrator first, maybe the social worker. And if you're still having trouble reaching the treating doctor, call Dr. Ruiz. Her phone number is listed on the slide because a lot of these facilities are DMH contracted facilities. Dr. Ruiz is the one that has these contracts with the IMDs. She will be able to assist you. Next slide. Okay, so if your loved one is involved with criminal court cases, oh, this is a difficult one. You can always, so your client will have a public defender within their criminal court. A lot of times, you can contact the court linkage program, social worker, psychiatric worker, and you want to be involved in letting them know that you want to be involved in their case, that you're the conservator and this is going to affect the conservatorship case. You can also ask for misdemeanor diversion program through ODR. It's a program that lasts 2 years. They'll get placed in a setting that may not necessarily be conducive to their mental health treatment, but it is to assist with the resolving of their criminal court case. Also know that if your client or your loved one is involved in a case where they've been charged with a crime, the court is the one who will determine what would be the best placement for treatment. If it's a felony case, most likely your loved one will go to the state hospital to receive competency restoration treatment. If it's a misdemeanor, they will most likely remain in jail because there's no restoration training program. The court will then determine whether AOT or a conservatorship is needed. We do get a lot of cases referred to us by the court on misdemeanors for conservatorship investigations. Gail, do you have any input?
Yes, on those, especially on the misdemeanor diversion programs, they're usually for 2 years. And generally speaking, if your loved one's been compliant and worked with them on that, at the end of the 2 years, many times the cases are totally dismissed as if they didn't happen. What I like about the LPS conservatorship when you're on one of these programs, if your loved one goes off the medication by that 53, 58.5, you can get them in the hospital, get them back on medication so that they will have a greater chance of completing the program with success. And then their case can be, dismissed. Or I'm not saying it will be, but the probability of it being dismissed is pretty great. So that's very helpful. And Los Angeles has done a great job with the jail diversion programs. They have a whole slew of them. Now, they cannot be, because if they're under the LPS, you cannot be under AOT at the same time, but they have other programs that they can work with on that.
Usually it's through the Office of Diversion and Reentry.
Right.
Be like a 2-year program where they're put in ODR housing. They'll get treatment for their mental illness, but the program is designed so that they could eventually have their charges dismissed and be able to go home to a FSP. They'll assist with housing after their program is done. So it could do well for someone who is resistant to treatment. For the felony clients, those cases usually come with an involuntary medication order, but not the misdemeanors. It's kind of implied that medication is necessary, but those cases usually don't have the involuntary.
Right. Yeah. These are really good programs, and they are very helpful. We've had pretty good success with them.
Yeah, the ODR has been very successful. Next.
Go ahead, Liliana.
Sure. So possible treatment programs. LPS conservatorship, that's usually the last resort if they're not successful in other programs. AOT program now it's going to be Care Court. It's going to be available December 1st. Home Team and FSP. These are other programs that your loved one can be referred to if they have been charged with a crime. Next slide, please. So medications, know all of your loved one's medications, know the side effects, the dosages, when they've taken, as Gail had said in the past, write them down in your notebook so that you can refer to them whenever you have to talk to social worker, doctor, research all the medications, know what kind of side effects they have, what their, efficacy is for your loved one's condition. You can also know what medication, works. You've known your loved one the longest. You've probably dealt with this longer than the public guardian has, so you know which medication works better, which one has had the most success. Write in your journal the date of the medications, when they were prescribed, what behaviors you saw. Did they improve? Did their psychosis improve? Their delusions improve? The goal is to find the best medication for clarity of mind with the least side effects. That's always the goal. You want to make sure that they're engaged in their treatment, that they're taking the medication daily. You know your loved one the best. Next slide. So guideline for medication. Gail, I think this one's for you. I feel like
Okay, utilize the scientific method. Remember when you were in junior high and high school, they talked about the scientific method. You change only one variable at a time. For instance, if your loved one's on 4 different medications and you say, okay, well, we want to take them off of these. If you take them off of all 4, you would never know if any were working. Or putting them on medications. You want one medication, try it, see what you think. If it isn't giving him back his life, now take slowly, because remember, the brain has to heal. Then you can take them off of it. But let's say they're on 3 medications and the doctor wants to take them off of 2 and things go all haywire. You don't know. So you do one variable at a time. If that works well, then let's do another one. Or if we put them on one medication and that's working well, then we can start to increase it and start to take off maybe another one. So once you know something's working, you can stick with it and then try taking them off something else. But the best thing is if you can find one medication that works the best, at what level, then if you have to add something, you do. And that journal is so vital to helping them find what's going to work best for them. We had a doctor at Silver Lake who had the patient on 13 psychotropic medicines. Want to tell us which ones was working? That was ridiculous. At the time, I didn't know we had 13 psychotropics. I know we do now, but well over that. But which one was really working? I called the CEO, he checked into it, and sure enough, got him off, well, titrated him off of all of those. You titrate slowly so that you don't have any adverse reactions. And if you do, then you can go add back, or if you're titrating up, you can slow it back down if you have to. Okay, next slide. The formulary, you want me to take this too, Liliana?
sure.
Okay, a formulary for medications. A lot of times the doctors will tell you, well, this is not in their formulary. Sounds like a big to do. It's not. It's one piece of paper that the doctor writes on there. We've tried this, this, and this. This is what we would like to try. Now, if the medication is expensive and you're trying it, you can contact the pharmaceutical company that produces this product and ask them to have their rep deliver free samples to the treating doctor. The doctor can give you the free samples and to see if that medication's going to work. And if it is, then you can worry about getting them on it. But a lot of times those doctors will tell you it's not in their formulary. They can write that up, request the medication, and try the medication to see if it's going to work. You want medication that works for serious mental illness, not for a person who has a mental health problem. And those are some of I suggested some when you take that NAMI family to family class. They have a great section on medications and they keep up with the newer ones. So, just don't be too hesitant not to try a new one. You never know. And you're starting at a low dosage. that you'll know the dosages, when you should see a difference, um, what the side effects are. Just keep in mind, even aspirin has death. So you kind of take it all with a grain of salt. But know your loved one's medications. If you're calling me and you're telling me they've been under the conservatorship for a year and they're having hallucinations and hearing voices and this and that, my first question to you is, what medications are they on? And I can tell you almost everybody who calls and they're telling me this problem, they're telling me Depakote, Ativan, Seroquel, and a billion other little nothings, which isn't going to cut it. It just isn't. And once they get them off of that and they get them on something else, it's like a world of difference. It's a miracle because that person is now getting their life back. The other thing is, do not settle. When the doctor tells you, well, that's the best your loved one's going to be. No, you remember what they were like beforehand because you looked at that photo of them. That's your goal. Now, sometimes you have to settle a little bit. Processing information is difficult for your loved one. So you might have to, talk slowly, not give them a lot of information at one time, allow their brain to heal. Get them in cognitive therapy so that brain can exercise and work better, and keep that journal. But find one medication that works the best. I'll tell you a situation I had a long time ago. A lady, the doctor kept telling her, well, all medications are the same. Well, shoot, I'd find another doctor if that's what he really believed. She finally convinced him to try her daughter on Invega. Within 3 days, she saw a difference. This kid was sick. She felt like Hitler was after her, Satan was after her. She was living in pure hell of fear. It was horrible. And the doctor just had her on this crappy medication. And he says, you're just a pushy mother. And she got another doctor after that, got her on the Invega. And the girl's been working ever since. That's been like 15, 17 years ago and doing wonderfully. I hear from her every now and then. And it's a pleasure when I hear from somebody who's doing well. It's delightful to know that they've got their life back. So it's important. And you guys are so blessed because your kids have that opportunity to get their life back. And I'm saying your kids, it could be your parents too, because a lot of kids are really trying to help their parents. Okay. Do you want to add anything, Liliana?
No, you covered it beautifully, Gail.
Thank you. Next slide. Placing the conservatee in a treatment facility. The intensive care division of Department of Mental Health is called normally by the hospital to come and evaluate the patient to decide where they're going to go. And I told you about the one situation where, 3 facilities didn't work. If you call the intensive care division or the hospital and say, well, I don't want them to go to that facility because you heard things about it, don't do that. Go and visit these places. Don't take other people's words for it. Go and visit the place. Make your own decision, but have your list of questions before you go there. You want to know about sex because you don't want to become a grandparent when they come out of there. Have questions about drugs, especially if there's a drug problem. Smoking. What therapy? Do they give them private therapy, group therapy? How often? What do they do? You want direct contact with the doctor when it's necessary. For the most part, you can go through the social worker. A whole list of questions. Visiting hours. When can you take them out to go out for lunch when they get better? That sort of thing. So these are questions that you can ask. As a conservator, by law, your request for placement will be honored as much as possible. Now, if they've offered you 3 facilities and they're all pretty good, and you want them in one facility, but that's not going to be available for 6 months, but another one's available for 2 months, of course, they're going to put them in the one for 2 months. If you give them a lot of grief, you can be removed as conservator. So you want to be very cautious how you work. You're working as a team to help your loved one get better. Now, when they go to a facility, and this is really important, they're going to ask you to sign a contract, giving them permission to treat your loved one. Write on that contract that your expressed written permission must be given for any change in medication, treatment, and placement. If you don't put that on that contract, and they're going to balk, but hey, it's a contract between you and them, that if you don't put it on the contract, as far as they're concerned, they don't have to notify you on anything. So they change your loved one's medication. They were doing great. Now it's going, what's going on? You have no idea. Find out if they have a group program where, not a group, but a team program where you meet with the doctor, the therapist, the social worker, your loved one, and you to discuss the process. And they should be doing that once a month, which is really kind of nice. So, and you might think, well, I don't want my loved one in there, but it's their life too. They want to know what you're thinking, and you want to know what they're thinking. So everything is team effort. Liliana, you want to add anything?
Just when Gail mentioned about the contract, anytime they ask you to sign off on the medication consent, I would recommend that you sign it as the conservator of your loved one and not just your name. So that way they know that the person given the approval is in fact the court-appointed conservator, not just
Great. Yeah, great suggestion. And I think you have to give all these facilities a copy of your conservatorship.
right. Definitely. That way they know that you are the one that they need to reach out to in case of any emergency. Any of you as a conservator are the one to give that.
Just one more thing. Sometimes the facilities will tell you that, well, we can't do this unless we have the conservatee's permission. No, they need the conservator's permission for doing things, unless it's something like, are they going to play basketball? Well, they need their permission to do basketball, not yours to say, yes, they can do it, unless there's a medical problem. But pretty much anything pertaining to their mental health has to be your permission, not the conservatee. Okay, next slide. Placement and treatment via the hospital. The hospital we talked about request ICD, intensive care division, to do an evaluation. They're transferred from, remember, a lockdown to a lockdown. IMDs are locked down. Hospitals and jails are locked down, so they can go from there to the facility as a lockdown. You cannot go from a board and care to an IMD because that is not a lockdown. Under the IMD is a residential security facility or housing facility, enhanced residential setting. That's what it is. It's a secure facility. Now, your loved one does not have to go from the hospital to an IMD. If they're in the hospital and they've got a good medication, they're getting clarity of thinking, cause and effect, they understand, what's going on and everything, and they're not a flight risk, they most likely can skip the IMD and go to the enhanced residential setting, which is a secure treatment facility. The general way of going is like IMD, enhanced residential setting, maybe a board and care or some other facility. That's generally, but they can skip groups as they get well. It's, in my opinion, it's not the best idea to bring your loved one home because when they come home, they revert back to their old self very quickly. And you don't want that happen. If you've had a kid that's gone off to college and they come home for the holidays, in college, they're doing their own laundry. They're being sure that they're eating, wherever it is they eat. They come home, they dump their laundry in the laundry room. Hey, mom, my dirty clothes are in there. And when's dinner? They revert back. You want them to be able to stand on their own 2 feet. You're not going to be here forever. And you want them to be able to handle their own situations. So generally speaking, it's not the best idea to bring your loved one back home unless you have a setting where they're kind of living independently, which is that would work. Okay, next. And that's a suggestion. It's not, set in gold or anything. Treatment and placement via the jail. Generally, they will send a person to a state hospital. Patton and Metropolitan are two good state facilities that they do a lot with the people who are mentally ill. And you are able to work with these hospitals if they go to these facilities. Okay, and as if it's going through criminal court, your right to approve or disapprove placement has been taken away. It's the court that says where they're going to go at that point. You still have input, but not as much. It's the court they are the ones that approve where they go. Okay, next slide. The normal, which we talked about, the normal movement through treatment facilities, an IMB, an enhanced residential setting, a board and care. We talked about going from a lockdown to a lockdown. The conservatee may skip a facility and go to a less restrictive facility as they improve their recovery. They can even go to an apartment many times and still be under the conservatorship. Okay, next slide. The doctor can request that you be removed as a conservator if you are not reasonable and if you are detrimental to their recovery. For instance, if you go, well, I'm not going to have them take any of these medications. I'm going to put them on holistic medications. You can be removed as a conservator. Now, you can do holistic, but it has to be so it's more advantageous. But if the doctor says they need a certain medication, then you kind of have to work with that doctor and go along with it unless you have a really good reason for them not taking that medication. Now, you can also change the doctors, like that one doctor that all medications are the same. The mother changed the medication, got her daughter on the right medication. The daughter has her life back and still taking, the medication. So you can change a treating doctor if the doctor is not what you feel is appropriate. And when you change doctors or you talk to therapists as they get out, interview them. What are their values? What do they think? Because you don't want to go to a doctor that says, well, I really like trying these psychotropic medications. Those aren't FDA approved. So be cautious of some doctors that come up with some of these. And there's some psychiatrists that are very interesting. Next slide. The conservatee's loss of rights. When they are placed under the conservatorship, they lose the right to drive a car, enter contracts, and determine where they live. Now, all those can be given back to them as they recover. The more permanent one is the right to possess and shoot a gun. And only one time, an attorney that I know of defended somebody and got him back his right to possess and shoot guns. And really, that particular situation was, it was very unusual. It was acceptable. But the right to drive a car while your loved one is under the conservatorship, they can have that right restored. you want them to get on the road for recovery. So they might have a job where they need to drive a car and get that right restored. Now, if the public guardian is their conservator, they're not going to do that. But as a private person, their parent or somebody, you can get that right restored. The right to enter contracts. And if you were listening yesterday, this one fellow went to Vegas, married 3 women in one night. All those contracts were void because he didn't have the right to enter contracts. They'll sign up for credit cards, get lots of money from the credit cards. They can't do that. Now, as they recover, you might want to give them back that right. Where to live. Sometimes working with them and saying, look, this is a facility we're looking at where we think you might like it. That would be good. And by the way, when your loved one goes to a facility, be prepared. The first 3 days, they're going to complain. Just kind of put, earplugs in and ignore it, because it takes them about 3 days to settle down. Then it's okay. And then they like it. So it's just what it is. Generally speaking, that's where it is. But as they get well, they can tell you where they'd like to live. And pretty much the only thing that you will end up holding on as conservatorship, because they'll be making all their own decisions, is the medication. And that's the essence of the LPS conservatorship. Okay, next slide. Liliana?
Oh, okay. Reinstating the rights of a conservatee. As Gail said, one of them is the right to drive a car. While they're under public guardian conservatorship, we do not allow our clients to drive a car. There's too much liability, and usually they probably don't even have one to drive. But a lot of times, instead of giving them a driver's license, we will get them a California ID. If it is time to reinstate their right to drive a car, then we're going to need a letter from the doctor stating that they feel that the client can drive and that their medications aren't going to interfere with that ability. It's very important that the medications that they're taking do not make it difficult for them, to make rapid decisions. It's important that they're going to be able to drive safely. The doctor will then fill out the form and submit it to the court so that the court can grant that disability back to the person. Once the court approves the right to drive, then the DMV will evaluate them and approve them and give them back their driver's license. Another one is the right to enter contracts. Usually, like Gail said, maybe a client wants to get married, a conservatee. They had a girlfriend, they want to make a life together. Giving them the ability to enter into marriage, that's potentially can, give them something to continue their treatment for, their spouse, their girlfriend. So the court can grant them that ability back. Next slide. Okay, the renewal of the conservatorship. So a conservatorship needs to be renewed yearly because they're, for some people, they can improve. They can return back to their former self with the medication, with the treatment. But in the instances where that has not happened and a conservatorship is still needed, you can begin the process 3 months before the termination of the conservatorship. So with the assistance of the court-appointed attorney, if you have one, you can file the petition for the reappointment. What you definitely will need, because the new judge needs it, is the doctor's declaration stating that the person is gravely disabled. So it's a form that you can download unless you already have it, that your loved ones treating psychiatrists will fill out, indicating that the person is still greatly disabled, unable to cover their basic needs of food, clothing, and shelter because of their mental illness, and will sign off, and that form must be filed with the court. So that is the doctor declaring that the person continues to be gravely disabled and that the conservatorship should be reestablished for another year. Okay.
If I can add,
Sure.
yeah, this is Los Angeles, and the public guardian has asked that you do the renewal start at 3 months early, which gives them time to do their investigation and get all the paperwork done. Each county, they might say 2 months or 1 month. So know what your county says on that. So even though this is not a law, it's just they ask that with our public guardian. And since our public guardians are so good, they try as hard as they can. We like to accommodate them.
The 3 months gives you time to get that doctor's declaration. Maybe you haven't been able to meet the doctor, get that form from the doctor. If you start the process early enough, it gives you some time before it terminates to get that form. So it also gives you time to talk to the doctor, because in certain instances, your loved one may not want to stay on the conservatorship. They might contest. So that gives you time to talk to the doctor about why the person is still gravely disabled, because you're gonna have to kind of prove that they're still gravely disabled. If they contest, then it's going to be up to them to prove that they are not gravely disabled. Again, you need to talk to the doctor, because if your loved one contests, then that doctor is going to need to testify and in court that your loved one still remains gravely disabled. Now, if your loved one does not contest the conservatorship, the doctor doesn't have to appear, and the conservatorship will be granted again. But that declaration needs to be submitted for the renewal of the conservatorship.
Yeah. And one more thing, you need 2 doctors to sign off. Do you need 2 doctors if they're not contesting?
Yes, it still need to be 2 doctors. Usually it's probably another person at the office there that is willing to agree, after reading the charts. But really, I've to my knowledge, I haven't seen or heard of any privates having any issues with getting that doctor's declaration.
Yeah, they usually don't. Now, let me just give you a heads up. When you're in court, one of the questions sometimes that is being asked is if they're contesting. The public defender will ask the doctor, when was the last time you saw them or you evaluated them? Be sure when that doctor's in court that they at least see your loved one that day, if possible. I mean, the doctor's there, your loved one's there, so that they see him. Because if he says, well, it's been a month ago, sometimes they have disqualified that doctor's statement. So you want to be sure when they're in court. You're just covering all bases. It might not happen, but if your loved one's contesting, be sure the doctor who's at court will see your loved one right then. And if they need another evaluator, they have lots of doctors at court. So they can many times ask one of them to evaluate them. Be sure you have that history, symptoms, and gravely disabled whenever you go to court, be it criminal or mental health court. Always have that. That really does help on a lot of cases on getting the results that you need.
I would also recommend that you have a conversation with your loved one, because part of the renewal process is, especially if they're contesting, is that they have a plan for self-care. And at times that plan is, mom, dad being able to go back home, live with them. They can use that and say that that is somebody assisting them with their needs of food, clothing, and shelter. So if you have not had a conversation with your loved one about that, that's probably, 3 months before the conservatorship renewal. maybe you want to have a conversation with them. And I'm sorry?
No, definitely.
That way your loved one also knows where your mind is, that, whether or not you feel that they're ready to get off the conservatorship.
Hmm.
Feel that they still need it, maybe, letting them know that, hey, we're going to renew it. You still need a little bit more to go. You're not there yet. So I'm not planning on bringing you home just yet.
Hmm. The other thing is, be sure on that gravely disabled, if you testify in court, you're testifying food, clothing, and shelter. That's what's most important. Nothing else is important. Well, till they change it. But all that pertains to safety and health risk. And be prepared, like Liliana says, have a conversation so you know what they're thinking. An example that was used was a young man goes to court and he tells the judge, hey, I can get a tent from the city. I can live on such and such street. I can eat 5 times a day at these food banks, and they get pretty good food there too. And I can get all the clothes I want at Salvation Army. He has a plan, and it's a viable plan, not what we like, but it's a good plan. I mean, for him. If the family had been there and said, yes, he can get a tent and go live on such and such street, but he is either victimizing people or he's being victimized, he's not safe. He can eat 5 times a day, but he doesn't. And he's lost significant weight from not eating. And he can get the clothes from Salvation Army, but he wears them for like God knows how long, doesn't shower, this and that. Now he's gravely disabled. That's the difference. So you want to be prepared that when they come up with things, you're going to be able to contest it and what you're going to say. And that's really important on keeping them on the conservatorship till they're ready to get off of it. Okay, next slide.
Okay, so definition of gravely disabled is being unable to provide for your basic needs, such as shelter, food, and clothing. But it's because of their mental illness. So their mental illness is the one preventing them from knowing where to go get, shelter, food, resources needed, to be safe and to be able to know when to go get medical treatment. So being able to address the gravely disabled part is really important in getting the conservatorship renewed. Gail had already covered it a little bit, so just kind of
reiterating.
Okay. Conservators court renewal court hearing. So your loved one has the ability to decide whether the judge gives a final decision on whether or not the conservatorship should be renewed, or if they want a jury trial. So in a jury trial, it's like a regular trial where 12 people decide based on the evidence that will be presented whether your loved one is gravely disabled. So a lot of times clients can present very well. They come to court clean, they are able to reiterate a plan and are able to convince 12 people that they are no longer gravely disabled. But your loved one has the ability to choose either.
Liliana, are the jury trials still taking about 3 days?
Yes, yes.
Okay. And that is, if they do the jury trial, sometimes that's not so bad because they're worn out. And where they can present well for 15 minutes, 30 minutes, whatever, by the third day, they are stressed and worn out. And then they kind of show what they're really like on that. But doing a jury trial is a real trip. And I'll just give you just one little thing that had, when we were doing the jury trial, we had, you're going through 12 people and you're asking questions to decide who's going to be on the jury, and you can eliminate so many of them. Well, we were down to picking out of the panel what was left over, what was left over. And this one older gentleman saunters up, the judge says, now I need to ask you a few questions. And he says, yes, sir, Your Honor, go ahead and ask. He says, do you understand what a conservatorship is? Yes, sir, Your Honor, I know all about that. It's all about money, ain't it, Your Honor? It's all about money. They're trying to conserve me. Judge says, okay, next one. But I mean, you get some characters, so you kind of have to think about who you want on that trial. And it's difficult. It's very difficult. Next slide. If the conservatee goes AWOL, even if they're not under the LPS conservatorship, file a missing persons report. When you file a missing report for a person with a mental illness, they go to the top of the missing persons file right under missing children, which as a dependent adult. So, and they don't need to have to be under the conservatorship. If they are under the conservatorship, give the conservatorship papers to the police, because when they find them, they'll call you and say, what do you want us to do? Please take them to the hospital. And you have that right. If they're not under the conservatorship, the police will call you and say, okay, we found them, they're doing fine. Sometimes the police, they're considerate and they'll tell you things, but sometimes they say, oh, well, but we can't tell you where they are. What you can do is say to the police, thank you very much for everything you're doing. I appreciate it. I'd like to buy you lunch or dinner or something like that. Could you tell me, are you looking at like a Denny's or a place you'd like to go for lunch today, or Starbucks or something? And I will see that they are paid if you want to go get something to eat. And they go, well, we're on the corner of such and such and such and such. Now you know where your loved one was. So you can probably get other treatment for them if you know where they are. There's also another facility you can look at under Outpost for Hope. They have a lot of information. While your loved one is home or something like that, try and get their DNA. I mean, God, I hope you never have to use it. But if they're willing to give you a swab, fine. Take it, put it in an envelope. Do not seal the envelope. You want it to air dry. Otherwise, it'll get bacteria in it if you don't let it air dry. Don't seal it. Or get, like when they brush their hair, if you can get some hair that's got the roots in it, keep that separate. So if somebody does go missing, you have it should something happen. I mean, I just pray nothing does, but we're living in a world that we never know what's going to happen. But do file the missing report right away the moment your loved one, if they go AWOL from a facility, file the missing persons report. The facility should be filing it, but don't count on that. Liliana, you want to add anything to the AWOL?
Normally, if our clients were to go AWOL, we check weekly on the sheriff's website. Anybody can use it, just in the event, they happen to get arrested, and at least you know where they're at.
Right. Okay. And if they go AWOL for more than 60 days, you don't know where they are, is it the termination, the LPS is terminated?
Well, you have to petition. You have to petition to have the conservatorship terminated. So if one of our clients goes AWOL for more than 60 days, then we have to petition the court to have the conservatorship terminated.
Do you have to do that as a private conservator?
No, you don't.
Okay, good. Okay, keep looking, because you want to get them back on that. Okay.
Some time to get it on calendar anyways. A lot of times, we've had our clients appear the day before the hearing for termination is heard, so we're able to have it withdrawn. It's up to you if you want to do it, but I wouldn't recommend it, because you never know. They might come, show up again.
Show up. Right. Keep it as long as you can, because they're so hard to get. All right, next slide. Leaving the state of California, LPS is specific law for California. California does not have reciprocity with other states. Like if they go to Nevada, they could call and say, hey, this person's under conservatorship. If you find them, send them back. Or if they're in the hospital over there, that LPS conservatorship is not viable in Nevada or any other state. Some states, mostly East Coast states, has a lot of reciprocity with other states, but California does not. If you choose to take your loved one, maybe to a wedding or something, you have to have the court's permission in order to leave the state. But if they leave the state and start acting up and there's a problem, you may have a hard time getting them back to this state, and that LPS is not transferable to another state. Liliana, do you want to add anything?
No, but if you do have your conservatorship here in the state of California, let's say LA County, and you want to move up north to San Francisco, you can have the conservatorship transferred to that county. So within the state of California, you are able to transfer. Not necessary, because everywhere in California usually honors the conservatorship, but if it's easier for you to renew in that other county, you can transfer the conservatorship there. Next slide.
Okay. I want to thank you all for coming today, giving us your time. I'm telling you, you have no idea how impressive you are, how powerful you are. Your loved ones are so blessed. They may hate your guts right now. That's okay. Give them time. As they get on the road to recovery, they will appreciate what you're doing. Our own son told us, you got me out of the darkness. And I don't want to go back there. I mean, sometimes I feel like he's going back there, but really, he's doing so much better. And we have our son back. So we are blessed. When you think you've had enough, the Navy SEAL team, which are tough people, they always say they can give even 10% more. And so when you think you've had enough, think you've still got 10% more in you, believe it or not. Take time for yourself. If you're having trouble sleeping, and I mentioned this yesterday, take about a half a cup of warm milk, drink that. Within 30 minutes, you're ready to pass out. Believe me, your mind is not racing, thinking, I have to do this, I have to do that. It's better than those melatonin pills that you buy at the store. It works really well. Watch a funny movie because it changes your chemistry in your brain so that you can handle this. You need your sleep. You need to take care of yourself so that you can take care of your loved one. Without you, honestly, the chance of your loved ones gaining recovery gets slimmer and slimmer if they didn't have you. So they are so blessed. They may not like you now. They may hate you. It's okay. They will in time, just like your child, you were disciplining your child when they were little. I hate you. I never want to see you again. And you send them to their room. They come out 30 minutes later. Mom, I love you so much. I'm so sorry. I mean, it's the same thing, only it's on a longer scale. So take care of yourself. That is really important. Liliana, would you like to add something?
I just want to thank everybody for coming to this training. I know it's probably been very difficult for you, but if you have any questions or concerns about the conservatorship process, I think my information is on the chat. You can email me or call me, and I'll try to help you as best as I can.
And that goes for me too. If you can donate, now if you're on Social Security or something like that, please don't donate, but if you have some extra money and you're saying, okay, I want to give to certain charities, if you could donate to NAMI Urban LA, that's the address, but put a note, this is for the LPS Conservatorship program. Araceli's running programs now in the Spanish program, and she's our webmaster. She's awesome. But, we would appreciate it very much because you really we're able to help a lot of people. And our goal is to help as many people get on the road to recovery as possible. And at that, I'm going to thank you, Liliana. I'm going to let Araceli take it away for questions.
Okay, so I'm turning on, you can start your video and unmute and raise your hand. I think in the chat I didn't see a lot of questions. Let's see. Or yes, I do see a few, but I guess if you could let me keep recording.